Hi, and welcome to Mortgage Solutions. I'm your host, Mark Rigney, along with my co-host, Jim Perkins. On today's show, we're going to tell you how to stop a foreclosure dead in its tracks. If you are receiving threatening letters from your lender and you really do not know what to do, then pay close attention. Today, we have the answers to get you out of the foreclosure trap and give you a fresh start on your mortgage. Jeff Greenberg from Legal Forensic Auditors is in our studio, and he will give you tips and advice to put you on the right track as it pertains to your mortgage. Hi, Jeff, and welcome to the show.
Thanks for having me.
Jeff, please share with us what it is you do and how one benefits from your services.
Well, there are a number of things that we do. My partner is actually a RESPA and TILA litigation attorney. Her name is Karen Kennedy. We're both from Fauquier County. I suppose in a word you could say that we're distressed homeowner advocates. I am a certified forensic mortgage auditor, which means that we take a very close look at somebody's origination documents to find out what violations may have occurred from the originator, the lender.
What documents are you referring to there?
Actually, since I wasn't 100% sure that I would remember all of them, I wrote them down. But,
okay.
What you need in order for us to do a complete forensic audit are the 1003, which is the original application,
right.
The HUD-1 or the final settlement, any notice in the event of a refi that is your right to cancel or right to rescind the note.
Okay.
We need the deed of trust and the promissory note. And a very important document is the final truth in lending disclosure.
How about the good faith estimate?
The good faith estimate's also very important.
Okay.
Sometimes there'll be two, and we need to take a look at those as well. But with those documents, we can do a thorough analysis, compliance analysis of the note.
Okay.
Now, Jeff, when you do a forensic audit, a lot of times, I know when I got my mortgage, I put those papers and I shove them someplace. A lot of times I would think that the homeowner wouldn't have the documents. Is there a way, or how do you obtain the necessary documents?
Believe it or don't, 80–90% of the time, the folks have pretty much all of the documents that they need.
Really?
However, if you go back to the title company, they're required to keep them for a number of years. But the way that we can force the documents out of the lender is called a qualified written request.
Okay.
Or QWR. If you search QWR on Google, you'll find a lot of information about qualified written requests, which is a legal method of forcing your lender to do something for you. What we typically do is we write the QWR in the event that the homeowner does not have the required documents in such a manner as to request the documents, and we show that it's a qualified written request. There's actually a sample qualified written request on my website that that homeowners can use if they wish to try that themselves.
Does it matter if the loan's been sold? They sell it from lender to lender all the time.
Yeah, they do, and that is who is going to end up owning the note. So who you send the qualified written request to is the servicer.
Now, when you send that qualified written request, if the person is in the process of foreclosure, can the mortgage lender go ahead and foreclose on them while they're waiting for those documents?
They actually can. The qualified written request does not stop a foreclosure.
Okay.
Even though it is a legally crafted document under Section 6 of RESPA, it does not stop a foreclosure action. However, there is something that it does stop. When you claim defects in a qualified written request, until your lender cures the defects that you have claimed in your qualified written request, and until they have cured what documents you have requested, they can't report you as late to the credit bureaus. It's illegal.
Okay.
But they could continue to go through the foreclosure process?
Sure.
Okay.
They can continue towards foreclosure.
In order for a resident to utilize your services, does one have to be facing a foreclosure or be underwater, have negative equity, if you will?
Not in order to use our services, but those are two very good instances where somebody might want to find an advocate that knows a little bit about this process.
Okay.
In the event of a foreclosure, and you open the show by saying, we'll teach you how to stop a foreclosure. There is something that the homeowner can do to stop foreclosure, and it's other than bankruptcy, which of course immediately stops all collection activities and creates an immediate stay of foreclosure. But oftentimes somebody doesn't need to go bankrupt in order to stop the foreclosure. HAMP, as a matter of fact, released in March of this year Supplemental Directive 1002.
Okay.
And Supplemental Directive 1002 basically describes some additional hurdles that the government threw in front of lenders in order to prevent this mad rush to foreclosure that it seems like the lenders are in the process of being on. And one of the things that that HAMP or Treasury Directive 1002 did was require that a lender be able to show documented proof of 4 months of loss mitigation negotiation with a homeowner that has applied for a relief under the HAMP program before they can foreclose on a home. And so that is one of the things that our shop does. We actually do it through Karen Kennedy. We will put a homeowner into the HAMP program, and that basically buys them 4 months of time, during which many times we'll be able to negotiate some sort of modification with the lender.
Okay.
Now, so a person that is not actually facing foreclosure, but is underwater in their property, in other words, they owe a lot more than what the property is worth, can that person still utilize your services or a portion of your services?
We have a specific service that is meant for people that are underwater, and we've actually created a separate corporation, or LLC rather, to offer that particular service, and that is the PRC, or the Principal Reduction Program. And in order to understand the Principal Reduction Program as we are doing it, first one needs to understand why the banks are in a rush to foreclose on homes.
Okay.
And in order to understand that, we have to separate those lenders out that are portfolio lenders from those that have purchased assets from the FDIC. And let me give a couple of examples. One West purchased all of the assets of IndyMac, a subprime lender, from the FDIC.
Okay.
Bank of America purchased the assets of Countrywide from the FDIC. JP Morgan Chase gobbled up WAMU, GMAC gobbled up Homecomings. And when they did that, when the FDIC takes over a bank and they take over all of the financial instruments that the bank owns, and they put an incentive, they put those assets up for sale in an auction type fashion on their site, or they have private arrangements they made. I mean, Bank of America was actually, I think, pushed pretty hard by the FDIC to take over Countrywide, basically because they were the big guy on the block, and Countrywide had a lot of subprime loans. Well, those assets are purchased at a discount, 60, 70 cents on the dollar. As a matter of fact, if you go to FDIC.gov and take a look at some of the banks that are in receivership and look at what you can purchase these assets for, or what past purchases have taken place, some of these pools of notes are being bought by 30 and 40 and 50 cents on the dollar. But let's go to case in my point. Let's go to the IndyMac purchase by One West. That transaction took place in the 60 cent on the dollar range, and so what that means is that One West, I mean, let's say that somebody has a $600,000 loan. That loan would have been purchased for $360,000 by One West.
Okay.
Okay, if it was originated by IndyMac. And let's say that that house is in Bristow, Virginia, a house that was built in 2006, and now it's worth $300,000.
Okay.
The reason that the bank is in a hurry to foreclose on that property is because they got a loss share agreement from the FDIC that guarantees a certain amount of any loss that they take on the portfolio that they purchase from the FDIC. I've actually brought a copy of the IndyMac One West loss share agreement, and if you like, I'll leave this for you guys.
Okay. Okay.
The reason that they would prefer, that they want to foreclose, and let's go back to our example, the $600,000 note. Let's say that the house is worth $300,000, I believe that's what we said. They paid $360,000 for that note. Okay. The face value of that note is $600,000, right?
Right.
That was the original amount.
That was the original balance, and let's say that it's an interest-only 10-year option arm, so the face value of that note is still $600,000. So they foreclose on that property and they sell it for $300,000. Okay? Now they're out of pocket $60,000, right?
Right.
Well, they get to take the loss from the face value of the note. So there's $300,000 that they're going to go to the FDIC and say, look, we lost $300,000 on this note. You guys guarantee 80% of it. So now they get a check for $240,000 plus the $300,000, $540,000 on a $360,000 investment. That's why they want to foreclose on homes quickly.
That explains a lot. Now, this is a very important question, Jeff. Some of our viewers right now are in dire needs. They're receiving the letters. What are the different methods that you have to stop a foreclosure, and how long will it take? If they need some action right away, how fast can you respond, and with what tools do you respond with?
All right. At the common denominator on everything that we do would be tied into the forensic audit.
Okay.
When we take a look at somebody's documents and find that the lender violated the Real Estate Settlement Procedures Act or the Homeowner Equity Protection Act or the Truth in Lending Act, specifically Regulation Z,
right,
which basically describes what the tolerances are on mistakes and disclosures. We can usually bring the bank to the table pretty quickly to negotiate something.
How long has been your experience?
After the audit is done,
yes, sir.
Typically if you send a rescission action to the bank, you'll be on the phone with them really quickly.
Right.
And
explain a rescission action.
Right.
I know what that is, but
okay,
for our viewers.
A rescission action, first of all, it is only a viable option in the event that the loan was a refinance. Rescission does not apply to a purchase money loan. And so the practical effect of rescission is this, and there are limits on the time in which you can do it.
Okay.
Before I even describe the practical effect of rescission, let's talk about a couple of causes of action that would allow you to rescind your loan.
Okay.
A very, very important document in that document list that we listed earlier is the Truth in Lending Disclosure. I mean, it's called the Truth in Lending Disclosure. Homeowners should be able to rely on that document,
right?
Wouldn't you say?
Yes.
Okay. On ARMs, on all of these hybrid mortgages where they're interest only or 5-year, 10-year option ARM, neg-ams, pick-a-pays, how in the world can somebody who's originating that note guess how much the finance charge is going to be over time?
Right.
Very difficult to do. You can't dial that in because you can't see what the LIBOR index is going to be in the future. And so we argue that the only way to describe to a homeowner and be anywhere close to being having any type of truth in lending, right, is to show them the worst case scenario. Okay, I mean
makes sense.
The Truth in Lending Act has specific tolerances. You are required. I mean, you can rescind your loan if the finance charge or the cost of money over the life of the loan is more than $100 off of reality.
Really?
$100.
Wow.
Okay, that's Regulation Z. And so these guys are way off. We're having loans where we're doing the full disclosure of the fully indexed loan that are hundreds and hundreds of thousands of dollars off. Most ARMs are off significantly. Okay. That allows you to rescind a refinance loan.
When you say rescind now, are you talking about complete forgiveness of the debt?
No, you don't get your house for free. That's a fallacy.
Okay.
Here's the practical effect of rescission. When you rescind